There is nothing that gets me angrier and more upset than when a defense lawyer asks my client in a wrongful death lawsuit, hey, how much life insurance did your family member have? Would you like to know why that gets me so angry and so upset? Come join me for a walk through the neighborhood as I share with you exactly why. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. I've seen this happen over and over again, where the defense lawyer who is questioning my client in a pretrial question and answer session known as a deposition, also called an examination before trial, in a medical malpractice wrongful death case, the defense lawyer will have an opportunity to question the surviving family member, most likely the surviving spouse. And during the course of questioning, I have seen this repeatedly, and this typically happens with a young, inexperienced defense attorney, where they will turn to my client and say, hey, Mr. Jones, how much life insurance did this person have? And you know what I say to that question? I say, objection! That is a palpably improper question. How dare you ask that question? You know better, counselor. Move on. And they are often speechless at that point. There is no response. There is no retort that they can make to that particular question. Why? Because that is an inherently improper question. What difference does it make whether my client had $1 of life insurance or had $100 million worth of life insurance? It has absolutely nothing whatsoever to do with the claims that we are making in the case, and it has absolutely nothing to do with the defenses that the doctor and the hospital are raising in this particular case. It's got nothing to do with the damages that my client will be entitled to, assuming we are successful in establishing that the doctor violated the basic standards of medical care and caused significant harm and injury. So the question concerns damages. The question concerns how much money he might have had in life insurance, he or she. Why do they do that? They do that to try and explore, to try and understand what assets my client had, what assets the surviving spouse and surviving family members will receive as a result of this person's death. Most of the time, they are not entitled to learn details of the assets that my client's surviving spouse has left. So why is it important for them to learn whether or not my client had life insurance? The answer is, it is not important. And let's say hypothetically that I didn't object, and my client went ahead and told them that my client had, let's say, $1 million worth of life insurance. Can they go ahead and use that during the course of trial? The answer is no. They cannot go ahead and use that at the course of trial. They cannot make an argument that said, hey, look, Oginski's client already has $1 million life insurance. Why should we go ahead and have to pay anything because of what our doctor did or what the hospital did? Because what good will this money do? That is a horrible, horrible argument to make, and that is not a good strategy. One of the reasons why these defense lawyers think they need this information is for settlement purposes. Now, what do I mean? Before trial, the judge, the court, wants to know if this case can be settled. And if there are settlement discussions, sometimes you will get a defense attorney to raise this issue by making the argument that I just did, which is, hey, look, the family has $1 million in life insurance. Why are they coming after my client, who we believe did nothing wrong? And even if he did something wrong, he would only be partially responsible and only responsible for X number of dollars. That argument still doesn't work. Why? When a doctor goes ahead and treats a patient, and now the treatment goes wrong, or now something is done wrong to cause significant harm and injury, the law says when that person now has sustained damages because of someone's carelessness, they become responsible and accountable for all of the injuries and the harms and the losses that that person has suffered. And that includes economic losses, financial losses to that person and to their family, as well as non-economic losses such as pain and suffering. In that instance, now it becomes important to understand damages. And the defense attorney is absolutely entitled to learn about what this person was earning. They're absolutely entitled to know what they were earning for the past few years prior to their death. They're absolutely entitled to learn about other elements of damages, such as their pain, such as the suffering that they endured from the time of the malpractice up until the time that this person died. That is absolutely true. But there's certain things they are not permitted. And when a defense attorney asks what I consider to be a throwaway question, hoping that I'm asleep and now they'll get an answer, that frustrates me to no end. And I get angry and I get upset and I voice my objection immediately, verbally, to the defense lawyer and make it quite clear that that is a palpably improper question that is not to be answered. And how dare you go ahead and ask that type of question? You should know better, counselor. And in fact, they should. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.